On January 30th, the Department of Justice announced what it called an unprecedented act of transparency. More than 3 million pages of documents, 2,000 videos, and 180,000 images, all connected to Jeffrey Epstein, were released to the public. Within hours, the internet exploded. Photographs surfaced showing a man who appears to be Prince Andrew, kneeling over a woman on the floor. No context, no date, no explanation, just images, carefully redacted, carefully framed, and instantly viral. But those photos are not the story. They are the distraction. From a prosecutor's perspective, the real story is not what the DOJ released. The real story is what they didn't.
Because while the DOJ told Congress and the public that it had fully complied with the Epstein Files Transparency Act, the numbers tell a very different story. The department itself identified over 6 million potentially responsive pages. Only about half were released. And yet, the DOJ declared the process finished. That matters because when a law says release all unclassified records, and the executive branch releases half and closes the book, that's not transparency. That's interpretation. That's negotiation. And in criminal justice, negotiation without oversight is where accountability goes to die. To understand why this document fight matters, you have to go back to where this all should have ended. In 2005, the Palm Beach Police Department opened a 13-month undercover investigation after a parent reported that Jeffrey Epstein sexually abused her 14-year-old daughter. By the end of that investigation, dozens of victims were identified, some as young as 13 years old. Evidence was overwhelming. The case was referred to federal prosecutors in the Southern District of Florida. That office was led by Alexander Acosta. Federal prosecutors drafted a 60-count indictment. At least 30 victims were prepared to testify. The FBI investigation was ongoing. Then Acosta shut it all down. In 2007, his office entered into what is now infamous, a non-prosecution agreement. Epstein avoided federal charges entirely. Instead, he pleaded guilty to 2 state-level prostitution charges. His sentence? 13 months. Work release. Up to 12 hours a day outside jail. 7 days a week. Even worse, the deal. Granted immunity to unnamed co-conspirators. Hid its terms from victims. Ended the federal investigation entirely. A federal judge later ruled this violated the Crime Victims' Rights Act. No one was prosecuted for that failure. More than a decade later, in July 2019, federal prosecutors in New York finally reopened the case. This time there was no sweetheart deal. Jeffrey Epstein was charged with federal sex trafficking. He faced up to 45 years in prison. 6 weeks later, on August 10, 2019, Epstein was found dead in his jail cell. The official ruling: suicide. But here's the part most people forget. When U.S. Attorney Jeffrey Berman announced Epstein's death, he said something very specific. The investigation into the conspiracy remains ongoing. That word, conspiracy, isn't casual. It's legal language. It means other people. Epstein may have been dead, but the case was not supposed to be. Yet once again momentum collapsed. No co-conspirators were charged. No trials followed. And the public was left with questions instead of verdicts. In November 2025, Congress finally acted. The Epstein Files Transparency Act passed with near-unanimous bipartisan support. The law was simple. Release all unclassified federal records related to Epstein and Ghislaine Maxwell within 30 days. The DOJ missed the deadline. They cited volume and victim privacy. Then, on January 30, 2026, Deputy Attorney General Todd Blanche announced the release and declared full compliance. But Congress immediately pushed back. What? Because the DOJ itself acknowledged over 6 million responsive pages, and released only about 3 million. House Oversight Democrats called it outrageous. Representative Ro Khanna, one of the bill's authors, said withholding files only protects powerful individuals. From a legal standpoint, this is critical. You don't get to redefine all because compliance is inconvenient. Even with half the records missing, what was released is explosive. The Prince Andrew photographs. Emails between Epstein and an account labeled the Duke. Messages referencing private dinners, lots of privacy, and introductions to young women. Other names appear. High-ranking government officials, business magnates, celebrities, foreign royals. An internal FBI document from August 2019, 5 days after Epstein's death, lists 9 associates. 8 are labeled co-conspirators. Only one has ever been convicted, Ghislaine Maxwell. 8 names. 7 never charged. Remember, The 2007 deal immunized co-conspirators. That legal shadow still hangs over this case. Congress has now issued subpoenas demanding the full unredacted files. They have not been fulfilled. Senators have asked whether all documents mentioning Trump were released. All co-conspirator memos were disclosed. The DOJ insists it would prosecute if evidence exists. But here's the contradiction. You cannot credibly promise accountability while withholding half the evidence. That's not how prosecutions work. That's not how justice works. This case is no longer about Jeffrey Epstein. It's about a system that failed repeatedly. 2007, evidence buried. 2019, defendant dead. 2026, records withheld. At every stage, powerful people were insulated. At every stage, victims were left behind. Virginia Giuffre, whose lawsuits forced much of this into public view, died in April 2025. She never saw full accountability. Institutional failure doesn't happen in one moment. It happens deal by deal, redaction by redaction, delay by delay. And until every document is released, every name examined, and every decision scrutinized, this story is not over. Because transparency delayed is accountability denied.